Well, good afternoon, Michiganders. It is Tuesday, January 10th, 2023. And of course, this is Tuesday with Tom, Michigan's only weekly podcast where we do answer your questions about estate settlement and estate planning in Michigan, and we don't send you a bill. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to this first episode of 2023. Well, one of the last episodes of 2022, I talked about 6 ways to avoid probate. So if you're looking at, maybe you've made a New Year's resolution, you want to get your estate plan in order in 2023, one of the things that you're considering is, how do I avoid probate? With respect to my estate plan, I suggest and invite you to listen to that most recent episode where I talked about 6 different ways to avoid probate. Today, though, again, keeping in mind that you might be putting together your estate plan in 2023, do you know what your estate plan must include? But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. What every estate plan must include. No, might be surprised. It's not a living trust. It's not a will. It's not a power of attorney. Those are not estate plans. They are merely strategies or tools that are used to implement your estate plan. So let's start with it. Let's start at the beginning. What is an estate plan? Well, I like to think that an estate plan is having made decisions about and made arrangements for, 1, the distribution of what you own at the time of your death, 2, having medical decisions made if you become incapacitated, and 3, managing what you own if you become incapacitated. That is what an estate plan is. Again, distribution of what you own, medical decisions, managing assets if you become incapacitated. And I break it down into some other parts. Let's start with what I consider the who chapter. The who chapter are things like, for example, who are you? Meaning, who are you? Where do you live? Are you married? Are you single? Do you have children, not children, etc.? Who do you want to receive your estate if you die tomorrow? So think about that. If you died tomorrow, who is it that you would want to receive what you own at the time of your death? And when you look at the who, do you have any concerns about that person's abilities to receive your estate? Maybe they're not old enough. Maybe they're minor children or minor grandchildren. Maybe they lack capacity. Maybe you have a spouse who has Alzheimer's, or a child who is incapacitated in some way, shape, or form. So they have some incapacity that you need to be concerned about. Or maybe they're a spendthrift. They just don't manage money very well. Or maybe stability in their relationship with others and stability in their relationship with you. Maybe you've got concerns about their uncertain government benefits, and they might lose those government benefits if they receive an inheritance from you. Or there might be others, but the idea is, do you have concerns about the beneficiary's abilities to receive your estate? Also, who do you want your estate to go to if that beneficiary predeceases you? Very many times clients will come in here and they say, look, I want an estate plan and I want something to go to my brother Bill. Well, what about if Bill dies before you? Where do you then want, who do you want to receive that particular distribution? So we need to go down a couple levels if we're going to put a complete estate plan together. Another who do you want to be in charge? Who is it that you want to task with this job of distributing your estate at the time of your death? And who do you want to make medical decisions for you? If you get to the point where you're not able to make medical decisions for yourself, who do you want? And those are the kind of the who's as part of putting this estate plan together. Now we also have the what chapter, what I refer to as the what chapter. Things like, what do you own? And as importantly as that, how is it owned? For example, if you have real estate, is the real estate just in your name, or is the real estate jointly owned with somebody else, or is it owned as tenants in common with somebody else? So how is it owned? Bank accounts. Is there a joint owner on the bank accounts? U.S. savings bonds. Do you have somebody on that bond already who is to receive the bond at the time of your death? So how are these assets owned by you are part of the what is it that you own? And then as important as that is, what are your estate planning goals? What are you trying to accomplish? What do you want to do with this estate plan? Maybe you want to maintain control of your estate after you die. You've got concerns about the ability of somebody to manage it. You want it to be managed for them. Another what could be you want the ability to change the plans as circumstances change. Things can change in the future. Maybe you, as part of your estate planning goals, want to make sure that you can change things in the future. Avoiding probate. That could be an estate planning goal. You've looked and said, at the time of my death, I prefer that my estate not have to go through the probate process. So again, that's an estate planning goal. An estate planning goal that many, many clients are going to have is to maintain peace and harmony in the family. They've seen it when someone dies, the problems that can sometimes arise between children, etc. And they want to have a plan in place that is more designed to maintain that family harmony. Perhaps you have a tax issue, and we talk about minimizing taxes or avoiding taxes when we're particularly looking at federal estate tax issues that we're dealing with. So maybe that's one of your goals, is to minimize taxes or avoid taxes if that is possible to be done. Another goal that most clients are going to have when they come meet with us is they don't want to overspend on their estate plan. They don't want to really spend any more than they have to spend. So maybe that's you. You're concerned about being reasonable in what you spend in putting this estate plan together for you. Medicaid. Many clients today are looking, saying, geez, it's possible, maybe one day I might have to go on Medicaid, or my spouse might have to go on Medicaid. So one of my estate planning goals could be to try and have an estate plan that also factors into what can I do with reference to saving my estate for my family if I had to go in a nursing home and we were applying for Medicaid. Another planning goal for some clients is going to be charitable giving, looking at their church, looking at their charities, whatever it happens to be. Maybe they want to incorporate those in this estate plan that they are creating for themselves. And you might have others. These are just the kind of the common ones that we oftentimes see when we're looking at what sort of estate planning goals do you have? Because at the end, then, when you look at the who you are and you want to receive your estate, and you look at the what you own and what your estate planning goals, then we can start looking at the tools or strategies that are available to build that plan. What tools, what strategies, what documents, what designations can be done, what deeds can be done, what beneficiary changes can be done, what TODs or PODs can all be done, different strategies that might be used to carry out those estate planning goals. Some people will choose not to do anything. They're not going to make any choices about anything. And in that case, they really have made a choice. They've made a choice not to do anything, But when you make a choice not to do anything, in fact, the state of Michigan has already made some decisions for you. It's what we call intestate succession. That's really what the state of Michigan has decided is going to happen to your estate at the time of your death if you don't make any other arrangements. Another strategy might be beneficiary designations. Maybe you're going to look at bank accounts and you're going to put a beneficiary on your bank account. You're going to put a beneficiary on a life insurance policy, or you're going to put beneficiaries on your IRAs and your 401ks, all those things that we can do, or maybe transfer on death designations or payable on death designations. But the idea is to have designations done with a particular asset so that upon your death, it automatically would go to the person who you've designated. So for example, a bank account. If you put a beneficiary on your bank account, it's still your bank account during your lifetime. But by putting the beneficiary on the bank account at the time of your death, now whatever's left in the bank account will in fact be owned by that person whose name you put on as a beneficiary. Another strategy might be some sort of joint ownership. Oftentimes spouses own their real estate jointly. They own their bank accounts jointly. They perhaps own investments jointly. And why do they do that? They normally do that because that's a strategy where one of their goals is to have the estate go to the spouse upon their death. One of their goals is that when that happens, not for the estate to have to go through probate. And so it's very common that they will look at some sort of a joint ownership on their home. So if my wife, Ginny, and I jointly own our home and I die, it is now her home. Doesn't have to go through probate. It ends up going to her, which is exactly what I wanted to happen with that home. So using joint ownership can be a strategy. Now, there's sometimes downfalls of joint ownership, and I've done plenty of episodes previously on this program about some of the downsides of joint ownership. So I'm just giving you some of the strategies today for you to think about. There's obviously a lot more work that needs to be done in making sure those particular strategies apply to you and don't have any negative consequences to them. Deeds, we look at preparing deeds. Maybe we're going to take real estate, we're going to make it jointly owned, so we're going to have a new deed prepared. Or maybe we're going to have what we call a ladybird deed prepared, which is essentially as though you're putting a beneficiary on your real estate, so it's still yours during your lifetime. Upon your death, it automatically goes to the person, or maybe your trust, if we're going to look at having a trust as part of your estate plan. Having a will, I said at the very beginning of this program, having a will is not an estate plan. Having a will, though, is a strategy. It's a way to carry out, perhaps, and accomplish the goals that you might have relative to what your estate plan is looking at accomplishing. So having a will, you've got minor children. In your will, you're going to designate guardians. Who's going to raise those minor children until they get to be adults? In that will, you're going to indicate what's going to happen to what you own and who it is going to go to and who is going to be in charge of those things happening for you. But it's a strategy. It's a legal document that accomplishes certain goals. Now, I'll say at this point, the one goal that the will does not accomplish, that many people have a goal to avoid probate. Understand that a will does not avoid probate. And if you want to know why, again, I invite you to listen to previous episodes of this program where I go at great length into why wills do not avoid probate. But it's a strategy that carries out somebody's estate plan. Trusts. Trusts are another strategy. There's different kinds of trusts. There's revocable trust, irrevocable trust, living trust, testamentary trust, different kinds of trusts that apply depending upon what somebody's estate planning goals are and how those strategies, i.e. trusts, are going to be used to accomplish those estate planning goals. In the area of healthcare decisions, the strategy there is going to be your healthcare power of attorney, the legal document in which you name the person or persons that you want to make medical decisions for you if you get to the point where you're unable to make those decisions for yourself. And then another strategy for incapacity planning, when we go back to the beginning, what I talked about as part of an estate plan, who's going to manage what you own if you become incapacitated? That's where your durable power of attorney is going to come into play, a legal document which again, you name the person or persons that you would want to take care of your estate for you if you're still alive, but you are incapacitated and can't manage that estate. So in summary, when you look at all of these things that I just talked about, what every estate plan has to include? A plan. It all starts with a plan. What are you trying to accomplish? Who are you? What do you own? What's important to you? Putting a plan together, that's what every estate plan has to include. And then different strategies are going to be involved regarding accomplishing different plans that different clients have. Well, that's going to be it for today's topic. Just a reminder, though, that Amanda and I would be honored to have the opportunity to help you protect your loved ones by putting together and helping you develop and create your estate plan, and then implement different strategies for carrying out that plan. Or perhaps amending a plan that you already have. Maybe you already have some legal documents and they need to be updated or changed, or some other strategies added to what you've already incorporated in your estate plan. Or perhaps you're looking for assistance in settling a loved one's estate. We would be honored to have the opportunity to help you. We're now having in-person consultations again. Before COVID, we had in-person consultations. Went through COVID where pretty much everything was being done remotely. Much of what we're doing is still being done remotely with clients. However, we are now offering in-person consultations in our Lansing office. Virtual consultations, though, are available. That would be either by virtue of a Zoom call, which many clients are familiar with, or a telephone call. So we're consulting with clients virtually, wherever you happen to be in the state of Michigan. And I would remind you, too, that if you have perhaps just a need for an individual document, maybe you already have everything in place and you're simply looking to have a new healthcare power of attorney created for you, or maybe a new certificate of trust. So I invite you, head over to our legal store, which is at doylelawpc.com. That's our website. And in the legal store, you're going to find individual documents that you can order online that can be prepared for you and delivered to you for you to execute. If you've got questions about any of that, setting a personal consultation, virtual, legal store questions, whatever, just simply head again over to doylelawpc.com. There you're going to find more information about all the different services that we do offer, and you'll have links that you can use to schedule that consultation, again, be it in person or virtually. Well, I think that is now going to be it for today's program. As always, though, if you have a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, then simply send me an email, tom@tuesdaywithtom.com. We invite you to please follow us on Facebook. I used to say follow us on Twitter, but we're not actively using Twitter at this point in time because of the number of changes that are occurring there. But please follow us on Facebook and invite your friends and family to follow us on Facebook as well. And that's going to be Tuesday with Tom. Also follow the office at Doyle Law PC. And remember, too, that the program is available on Apple Podcasts, Spotify, Google Podcasts, iHeartRadio, Spreaker, many other services. Wherever it is you likely listen to your podcast regularly, you will find our program available for you. And if you have a smart speaker at home, you can always ask your smart speaker to play Tuesday with Tom. Well, thank you again for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.